Hi everyone! Welcome to Lawyer Up by NDV Law. I'm Attorney Karlo Nicolas, a senior partner of Nicolas and the Vega law offices. Today, we are going to discuss about how to sell your business in the Philippines. Selling your business, it can be motivated by many factors such as inability to continue the business losses, buyout by a competitor, a handsome offer given by an investor, to name a few. The decision to sell your business will depend upon your sound business judgment and forecasts on the movement of the market. But whatever reason impels you to sell your business, the law provided for a proper procedure with such sale. Act number 3952, as amended by Republic Act number 111, otherwise known as the Bulk Sales Law of the Philippines, primarily governs the sale of a business. This law is aimed at protecting creditors and suppliers from the sale by merchants or debtors of their business, unduly prejudicing the former's rights. However, it must be noted that not all sales are covered by this law. In order for the bulk sales law to operate, the sale or transfer must be done in bulk. Therefore, Section 1 of the Bulk Sales Law considers any of the following as sales in bulk. Number 1, any sale, transfer, mortgage, or assignment of a stock of goods, wares, merchandise, provisions, or materials other than in the ordinary course of trade and the regular business prosecution by the vendor, mortgager, transfer, or signer. Number 2, any sale, assignment, transfer, or mortgage of all or substantially all of the business or trade, therefore, conducted by the vendor, mortgager, transferor, or assigner. Number 3, any transfer, sale, mortgage, or assignment of all or substantially all of the fixtures and equipment used in or about the business of the vendor, mortgager, transferor, or assigner. Not all bulk sales law are under the purview of the bulk sales law. The following transactions are not covered. Number 1, if the seller, mortgager, transferor, or assigner produces a written waiver of the provisions of the bulk sales law from his creditors as shown by verified statements. Number 2, executors, administrators, receivers, or assignees in insolvency or public officers acting under such processes of the law. If the sale of your business is covered by the bulk sales law, then you need to do 4 things. The first, the delivery of the sworn statement of listing of creditors to the buyer or mortgagee. Second, prepare a written advance disclosure to the creditors of the sale. Third, the application of the proceeds. And fourth, the recordal of the sworn listing with the Department of Trade and Industry. Now regarding the first step, before you receive any of the purchase proceeds from your buyer, you must deliver to the buyer a written statement of the names and addresses of your creditors, together with the amount of indebtedness owing to each creditor. With regard to the second step, you must at least 10 days before the sale, transfer, or execution of a mortgage upon any stock of goods, wares, merchandise, provisions, or materials in bulk, make a full and detailed inventory thereof, and to preserve the same, showing that the quantity, insofar as is possible with the exercise of reasonable diligence, the cost price to the vendor, transfer, or mortgager assignee of each article to be included in the sale, transfer, or mortgage, and to notify each creditor whose name and address is set forth in the verified statement of the vendor at least 10 days before transferring possession of the goods, personally or by registered mail, of the price, terms, conditions of the sale, transfer, mortgage, or assignment. Now, as to the third step, you must apply the purchase money to the pro rata payment of the bona fide claims of the creditors as shown in the verified statement. The requirements of the bulk sales law must not be taken lightly. If the sworn listing is not prepared and delivered and the pro rata payments not made to the creditors, such sale or transfer of the business is considered fraudulent and void. Therefore, the sale is not valid and no transfer of properties or business results therefrom. This effect is regardless of the motive or good faith of the seller. Moreover, a violation of the bulk sales law opens the seller to criminal liability for imprisonment of not less than 6 months nor not more than 5 years, or a fine in a sum of not exceeding 5,000 pesos, or both, such imprisonment and fine in the discretion of the court. However, non-compliance with the second step, which is the written disclosure, and the fourth step, which is recordal with the DTI, will not affect the validity of the sale or transfer. It must be made known that it is also unlawful for any person, firm, or corporation, as owner of any stock of goods, wares, merchandise, provisions, or materials in bulk, to transfer the same without consideration or for a nominal consideration only. We have now discussed about how to sell your business in the Philippines. If this video has been helpful to you, kindly hit that subscribe button. You can also visit our Facebook page and our website, ndvlaw.com, for a wealth of legal resources. Again, this is Attorney Karlo Nicolas of Nicolas and the Vega Law Offices, and thank you for watching Lawyer Up by NDV Law.